Yesha Yadav, Professor of Law and Associate Dean at Vanderbilt Law School. Thank you very much for joining us once again here on Crypto World.
Talia, thank you so very much for having me. It's such a pleasure to be here. Your show has been incredible over these last few months to help make sense of everything that's been going on. So thank you so very much for having me on today.
Thank you for your kind words, and we're excited to hear your insight. It has been a few months since we spoke about crypto here on the show, and a lot has happened
A
since
lot.
then. I want to start off with your reaction to Representative Hill's comments on Squawk Box this morning, where he argued that the SEC's current approach of regulating crypto by, quote, trying to cram the digital assets, infrastructure, and ecosystem into existing laws just doesn't work. You actually wrote a research paper this year on regulation by enforcement. So I'm wondering, what do you think about Representative Hill's argument?
Crypto has been this incredible challenge for regulators to make sense of. This has been from the very start where there's been continuous arguments about whether this thing is a security, whether it's a commodity. That has meant that we're not even getting to a first base with respect to having rulemaking that can provide some kind of roadmap for the industry and perhaps more than anything to start protecting customers. The biggest vulnerability that we're dealing with here is that customers are exposed. There are billions in assets in different crypto custodians' vaults. These assets, there's no real regulatory framework to address how to keep them safe, to keep them remote from bankruptcy. The consequences of that lack of action has become incredibly apparent over this last year when the multiple bankruptcies affecting Celsius, FTX, Voyager, and others have left customers in the hole, wondering whether or not their assets are safe. And for many, ending up as unsecured creditors, for example, in the case of Celsius, and therefore last in line essentially to get paid out. So what we need here are rulemaking. Now, of course, agencies have a ton of discretion, as I wrote about in that paper alongside Chris Brummer and David Zering, have a ton of discretion as to how they engage their mandate and carry out their duties. They can take enforcement actions, they can do rulemaking. The question is for them to use all of this regulatory power that they have in a way that can be effective, get customers protected, provide market integrity, stability. And so the SEC, CFTC, and others have a bunch of power to do that. The question is, just getting to that first base, getting everyone's heads together, or asking Congress to really get serious about putting some kind of bill together that can move the dial forward here. We're really falling behind, and unfortunately the cost here is being borne by customers most of all, and the savings that they put in line in the crypto markets.
We'll talk more about crypto regulation in just a bit, but I want to turn to other major news, that settlement between Binance, the world's
Yep.
largest crypto exchange, and US government officials. What was your immediate reaction to that historic settlement by the US Department of Justice and the fact that Binance's CEO pled guilty to violating the Bank Secrecy Act?
Talia, it was a pretty seismic settlement on many levels. I mean, firstly, it came as a surprise, I think, that CZ would plead guilty. But then again, perhaps not, given everything that we have seen with Sam Bankman-Fried and the potential decades that he's looking at following his conviction last month. And so, it did come as a surprise, but this settlement is extremely significant on a number of levels. I mean, firstly, for Binance itself, it's a pretty hefty fine. The biggest thing here is this monitorship that the US has put in place. Now, what this means essentially is a complete sea change in how Binance has been run over this last sort of 2017 onwards since its creation. It has been very, very explicitly this borderless exchange where famously CZ has said that wherever his office is where the exchange is. I mean, this has been an exchange that has run in accordance with his personality as the animating force. The governance in Binance has been notoriously opaque. And all of that is about to change in a really big way. This monitorship means that Binance's affairs will be very closely scrutinized going forward. This whole notion of this borderless exchange without a primary regulator is certainly going to change going forward. This monitor will have eyes on everything that Binance is doing. Most likely it will have to pick a headquarters now. And the way in which it's going to be run is not going to involve CZ anymore in any significant way. So the entire governance architecture of this exchange is going to change, as well as the kind of risks that it has been taking growing up. And so that's bound to have a massive impact on the industry, given Binance's position in this industry at this present point in time. Now, obviously, as you know, Talia, Binance's trading volumes have been falling since 2020, since this last year. Approximately 60% of the spot market last year, and approximately 40%, at present. So it's really lost market share since January of this year. But at the same time, its impact, its effect is undeniable for the marketplace. How it runs itself, the kind of products it puts out, the kind of governance norms that it espouses, these are all extremely significant for the influence that they have more broadly. If you recall, post FTX, CZ and Binance have been trying to position themselves as kind of regulatory spokespersons for the industry as a whole. CZ, for example, announced a stabilization fund. They were talking about proof of reserves as a way to kind of provide some transparency into the exchange. So, these are things that Binance was trying to lead because of its dominant position in this marketplace. Now, what it's going to do going forward, how its governance norms, brand new, will be implemented in Binance 2.0, this is likely to have some impact for the structure of the industry more broadly with respect to things like risk management, governance, customer protection, and so forth.
Several industry insiders argue that the Binance settlement is a pivotal moment for the crypto industry. Some argue that it highlights the need for crypto exchanges to prioritize regulatory compliance and adhere to established financial laws and standards. Robert Lay, a crypto analyst with the research firm PitchBook, argues that the enforcement action could signal a broader shift towards stricter regulatory oversight in the crypto industry. Do you agree with that argument? What's your thesis?
Well, it changes the approach that many exchanges, particularly those offshore, have taken, which is to adhere to the principle that because they're offshore, that potentially they may be safe from criminal prosecution here in the U.S. Now, clearly, the Binance example has shown that that cannot be true, particularly in the case of AML AML and anti-money laundering and sanctions and compliance here. The US is well known as having very powerful extraterritorial reach in this context. And that is something that has been demonstrated given that the Department of Justice has spectacularly brought Binance to heel in this context. So exchanges around the world, whether they're offshore, the kinds of businesses they're doing, the business, the people they're doing these businesses with, they're certainly going to be on notice here, and particularly founders that are working closely with respect to designing how the exchange is working, what the exchange is doing. These founders are on notice too, given the fact that CZ has pled guilty and is potentially looking at some jail time, though it's not clear exactly how that might work out. 18 months, it looks like, in the current plea agreement, but it can go up to as much as 10 years. So certainly there is a broad notice across the industry as a whole that the U.S. Is taking a kind of responsibility as a global policeman, particularly in this context of anti-money laundering and sanctions. So, that is certainly one thing. More broadly, of course, as Robert's pointing to, there needs to be some kind of clarity as to what exchanges also have to do with respect to compliance. So it's going back to our earlier conversation, Talia, here in the US, we need to work on a framework for oversight for exchanges, for standards like disclosure, risk management, customer protection. Once we have that in place, that provides a clear roadmap for exchanges to comply with. And globally, we also need to think about standards for international exchanges that are doing business in multiple jurisdictions. At present, we have a fragmentation of regimes around the globe. So we have the market in crypto assets regulation in the European markets, MiCA, Singapore is doing their thing, Canada's done its thing. So there's a fragmentation of regimes, but no international standard here. So one issue that we're all dealing with respect to thinking about how exchanges, get to be the gold standard for compliance and how they get to that point is actually having clear standards for them to comply with on a comprehensive basis to cover aspects like customer protection, disclosure, and risk management. And, certainly globally, we're not there yet. And certainly not here in the US, as we just discussed.
So when we spoke in February, you stressed that the crypto industry needs regulation extremely quickly as the industry's reputation was severely tarnished following the collapse of FTX and other scandals that you noted earlier. In fact, you testified on Capitol Hill a few months after FTX's implosion, stressing the need to get a regulatory framework up and running right away. We have seen some advancements here in the US since that massive failure. Over the summer, for example, US lawmakers advanced the Fit for the 21st Century Act to establish a crypto framework. Based on developments like that, Do you think lawmakers accomplished enough? And how do you feel about that crypto framework overall?
Unfortunately, Talia, I'm not feeling super optimistic. It's been a year since FTX has collapsed. We have seen, multiple abuses emerge from that disaster with respect to how customers were treated, with respect to what happened to that money, as we saw with, in the SBF trial over this last month. Just incredibly cavalier attitudes across the board with respect to how customer assets were handled. All of this is pointing to a severe need for clear rules on protecting customers, giving them clear information disclosure, making sure that their assets never enter into bankruptcy, ensuring that custodians are, incredibly well run, that they have the best in class standards with respect to cyber protection, operational risk management, all of that. We have that in traditional securities and commodities markets. We've done all of that work to create standards for exchanges, for custodians, for different parts of the clearing and trading and markets ecosystem. We've done a whole bunch of work on that. But for some reason, we're not able to get to that starting point where we're incorporating these principles into crypto markets regulation. Now, certainly, as you mentioned, Talia, a bunch of work has been done getting bills to the floor. This is incredibly powerful work, important work to advance the needle and the dialogue. But we need to get this over the hill and actually have a piece of legislation. And once we do, it's going to take years for that to even get implemented. So, we're not even at that first base yet. And of course, as you know, Talia, election is coming up next year. I don't believe that crypto regulation is going to be a priority for lawmakers in this context. There are going to be other things that they're going to worry about that's going to make sure that, that constitutes the kind of policy priorities that constituents in their regions want to see. So I'm not optimistic about crypto regulation actually going past this line before the election next year. It doesn't feel like we're there yet.
Now, when we spoke back in May, you stressed that one of the dangers of not having comprehensive rules is that the US loses the international race to set standards, which you say is something that should be of huge concern to anyone that works in financial regulation. So I'm wondering, how would you rate the progress here in America since then, especially compared to the regulatory advancements in crypto in places like Singapore, Dubai, and the EU? I asked a few other industry experts the same question, but I'm wondering what region you think is winning the race as it pertains to crypto regulation.
Well, the US is traditionally in financial markets regulation being the clear global leader in standard setting. That has been particularly dominant since the financial crisis, where the US has been the undoubted mover in ensuring that we have standard global rules of the road for things like bank regulation, for making sure that derivatives, for example, are properly, overseen and their risks managed carefully. The US has done that, and there's a very good reason for that. We have incredible agencies. We have terrific experts in these agencies that have worked incredibly hard to produce rulemaking that, has meant that there's a level playing field for global capital in the marketplace internationally. Now, unfortunately for crypto, we have fallen behind in this context. The standards have been set, particularly by jurisdictions like the EU with MiCA. The EU has taken a very clear categorical step in telling the world that, they are essentially open for business for attracting crypto capital and innovation and risk management technologies and so forth. And so there's obviously this danger here in the US that we see business going abroad. This is, something that has taken on some momentum as well, given the fear that certain folks in the industry have with respect to enforcement as well. And so there has been this, at least a threat, if not an actuality, for businesses to go abroad where regulatory frameworks exist. For example, in the EU, in Singapore, the UAE, and other jurisdictions. Now, for us, the biggest danger in that is that we become rule takers. In other words, that rules get fashioned in different jurisdictions. They set the standards with respect to what kind of disclosures customers should get, with respect to what kind of risk management customers should expect, with respect to things like custody. What kind of operational standpoints custodians should provide their customers. These are things that other jurisdictions, other lawmakers can decide, and we have to accept that because, we're dealing with a a marketplace that is international, where people, where companies and customers can choose where to do business. And so we essentially, start to mimic what other countries are doing in order to attract that business here. Alternatively, we try and go it by ourselves, produce our own standards, do our thing, and that does create some potential compliance costs for companies that wish to do business here as well as in other jurisdictions, and so they may not choose to come here for that reason. So having an international framework, ensuring that there's cross-border cooperation to deal with this very international, essentially in some ways very borderless industry is imperative. But unfortunately, given the delay in getting U.S. leadership put in place here has meant that we are looking to other people's standards right now to look at what they have done rather than coming up with those creative solutions ourselves. And that is not a position that we are used to being in. It is the opposite position that we are used to being in.
That's exactly right. So, which jurisdiction would you say is leading the race right now?
Well, I think if you look globally in terms of the overall market share, it's probably going to be the EU. It's a marketplace of 300 million odd people. It's you can passport across 27 odd countries once you've established in one. So it does create a great deal of just create a great deal of incentive for businesses to try and experiment or to go into the EU for undertaking their crypto businesses. But of course, there are other countries as well, like you mentioned, Talia, the UAE, Singapore, and others. And they are all competing. Now, one challenge with this competing dynamic, of course, is that jurisdictions end up in a kind of race to the bottom in some ways. That's the classic danger, that jurisdictions trying to attract crypto capital put lower than optimal standards in place in order to get businesses to come to their shores. So this is why we need global coordination across the board. So we have a set of agreed standards on things like customer protection, on things like market integrity, operational standards, password integrity, and making sure that passwords are safe. We have global standards here because, of course, we are mindful of that race to the bottom. And given the fact, as we saw in the case of FTX in the Bahamas, one weak link here in the global marketplace can create enormous costs for the system as a whole. So this is something that has to be addressed ASAP by international regulators, global standard setters, to get countries on the same table. So even though they look like they're doing their different things, we can all at least agree that there's some kind of common standards. And the US traditionally has led that kind of initiative as part of the international structure. It's not there yet. And the consequences we can see today are that there's a massive fragmentation in how jurisdictions are approaching crypto. And that does create, Talia, this incredible danger that, we end up with weak links in the global jurisdictional ecosystem.
Going back to regulation by enforcement, obviously it's an approach that has not been popular with crypto companies, including Coinbase. After all, the SEC filed a lawsuit against that crypto exchange back in June. Just last week, we saw more enforcement action with the SEC suing another crypto exchange, Kraken, for allegedly operating as a securities exchange without registering with the regulator. Kraken's also accused of having insufficient internal controls, reflected in part in its commingling customer money with its own and paying operating costs from customer accounts. Kraken says it disagrees with the SEC's complaint against them. What's your reaction to that development?
So, regulation by enforcement is the approach that looks like, one that has been taken over this last, since for a few years, where oversight of the marketplace has been pursued by trying to enforce existing rules against the industry as a whole. Now, one thing to think about here is that, of course, agencies do have masses of discretion to do this, but they've also, opening themselves up to risk. And that risk has materialized for the SEC recently, where the SEC has faced pushback in the appeals court, for example, in the Grayscale decision, where the SEC was, faced pushback and critique for taking actions that looked arbitrary and capricious. So, one thing to think about here is, as outlined in the paper with David Zering and Chris Brummer, is that we need our agencies to do their job. We need our agencies to be protective. They need that authority to do their work. And one of the risks that is materializing is that the agency's authority itself, the perception of their legitimacy, the perception of their fairness, is being challenged because courts are pushing back on enforcement actions that are potentially seen as being overly aggressive. There are a couple of other larger movements to be mindful of here, which is that there are court cases that are moving to the Supreme Court that could challenge the authority of the administrative state to do to perform roles that it has done traditionally. So, for example, next year, Chevron deference is likely to be, brought before the Supreme Court. That is a rule, a doctrine that has given enormous deference to agencies to do their thing. In addition, obviously, there's another case called Jarkezi, which challenges agencies' own adjudication procedures. There's the major questions doctrine that came up last year, where places where the agency where authority may not be super clear cut, that those issues should be put before Congress. So there's a larger threat, as it were, risk to the administrative state as a whole. And that is the ecosystem in which agencies are stepping into when bringing ambitious, actions against different players in the crypto ecosystem. And this is something that agencies, need to think about as outlined in our papers. One of the risks that, comes from an enforcement approach that potentially looks like it could be aggressive and stepping into, taking big swings into ambitious areas.
Yesha Yadav, Professor of Law and Associate Dean at Vanderbilt Law School, thank you very much for that comprehensive insight into crypto regulation and all the latest crypto headlines. It's always a sincere pleasure speaking with you.
Talia, thank you so very much for this conversation. It's always a joy to get to have this conversation with you. So thank you so very much for having me on the show today.